Nicholas Sandmann is suing the Washington Post for defamation. One American News is suing Rachel Maddow for defamation. Tulsi Gabbard is suing Hillary Clinton for defamation. Donald Trump is suing CNN and the New York Times for defamation. And it looks like Sean Hannity is saying, hey guys, don't forget about me. Viva Frei, Montreal litigator turned YouTuber, working out of my home office, because when you are stuck at home for 8 weeks with 3 kids and 2 dogs, your car becomes the quietest place in your house. We are now entering what I believe is week 8 of the lockdown in Canada, and you want to know how bad this Groundhog Day has gotten? I forgot to have coffee this morning.
At
about 9 o'clock in the morning, I'm walking around the house, particularly cranky, questioning my own existence, and not knowing exactly why, when I stare over at the pot of coffee and see that my cup of coffee is still in that pot. But I digress. It looks like Sean Hannity is going to be suing the New York Times for defamation. Now, this is going to be particularly fun because typically by the time I get around to doing a defamation vlog on a subject, proceedings have been filed and the letter of demand and the response to the letter of demand and any inter-attorney correspondence are exhibits to that lawsuit. This is somewhat of a unique situation in that proceedings have yet to be filed, and all that we have is the letter of demand coming from Sean Hannity's attorneys and the response to that letter of demand coming from the New York Times attorneys. And we are going to go through both of those because they're phenomenally interesting reads, and I am predicting that lessons probably will be learned. First things first, before we get into the substance of the letter of demand, I want everyone to appreciate that Sean Hannity's letter of demand is 12 pages long. 12 pages long. Now, admittedly, it does have excerpts from articles and links, which accounts for the length somewhat. But I once had a mentor tell me that if it's taking you more than 3 or 4 pages to make your point in a letter of demand, you are making your point wrong. When it comes to the practice of law, especially litigation, less is more. From letters of demand to proceedings to depositions, less is more. The less you say or do, the less it can be held against you. So when I see a 12-page letter of demand, even if it's written without prejudice, because without prejudice doesn't mean that people can't hold the things you say in that letter of demand against you, I start to ask questions. With that said, let's dive into this letter. Harder LLP. I appreciate that that is one of the partner's last names, but when it comes to a name for a law firm, Harder is not bad.
Got litigation? Get harder.
Sean Hannity, demand for retraction and apology. This is something we've touched on in previous defamation vlogs, but in certain jurisdictions, in certain states, in order to be entitled to certain types of damages in the context of a defamation lawsuit, a demand for retraction has to have been made within a certain delay of becoming aware of the allegedly defamatory article, and there has to have been a refusal of the retraction in order to qualify for certain special damages. I am not sure what state or jurisdiction this lawsuit is going to be filed in, if in fact a lawsuit is going to be filed, but I suspect this is why there is a demand for retraction in the first place. This firm is litigation counsel for Sean Hannity. We write concerning the New York Times' blatant and outrageous disregard for the truth in mischaracterizing Mr. Hannity's coverage of the My Sharon Osiris Schmandschmandrick and blaming him for the tragic death of Joe Joyce. This is also something I have said multiple times in previous vlogs, but it's not because you say something is something that it is what it is. Using hyperbolic and inflammatory rhetoric to describe something doesn't necessarily make it so. Don't give me adjectives, just give me facts and lead me to where you want me to go, and don't think you're going to get me there any faster by pulling me by the collar, because I've got to say, Sean Hannity's lawyers came on a little strong. In a story you published on or about April 18, 2020, entitled "A Beloved Bar Owner Was Skeptical About the Cyrus, Then He Took a Cruise," available at link, you falsely state and falsely imply a connection between Mr. Hannity's on-air comments and Mr. Joyce's decision to take a cruise. But what you fail to mention is that Mr. Hannity's comments could not possibly have influenced Mr. Joyce's decision because he embarked on his cruise on March 1, according to your report, while Mr. Hannity made comments on March 9, which you claim influenced his decision. Moreover, you were fully aware that this was the actual timeline, and in order to mislead your readers and support your false narrative, you withheld the date of Mr. Hannity's comments from your story. But wait, there's more, and I tell you that meme is never going to get old. It's never going to get old.
But wait, there's more. Hang on to your seat, baby, cause this one's a screamer.
It might get old. The April 18, 2020 story is one of many instances of your ongoing campaign to personally attack Mr. Hannity by mischaracterizing and making false statements with respect to his coverage of the My Sharon Osiris Schmandschmandrick. By way of example, in another story published by you on or about March 31, 2020, entitled "Fox's Fake News Contagion," you falsely state and imply that Mr. Hannity is responsible for determining all of Fox News coverage of the Sharon Osiris, regardless of program or host, and you again falsely state and imply that Mr. Hannity has downplayed the seriousness of the Sharon Osiris Schmandschmandrick and given the public misinformation about the Schmandschmandrick as follows. You can relax, Sean Hannity, I'm not going to sue you. Some people are suggesting that there might be grounds for legal action against the cable network that you pretty much rule, Fox News, because you and your colleagues dished out dangerous misinformation about the Cyrus in the early days of the crisis in the United States. Some might allege that they have lost loved ones because of what was broadcast by your news organization. And talk about people living in glass houses. The New York Times is going to accuse Fox News of misinformation and fake news. This is just... lacking insight and self-reflection. Your foregoing statements about Mr. Hannity in the March 22nd, March 31, and April 18, 2020 stories, collectively the stories, are false and defamatory and extremely damaging. First, you're reporting that Mr. Hannity's comments in any way influenced Mr. Joyce's decision to take a cruise is demonstrably false. Mr. Hannity could not have influenced Mr. Joyce because the statements that you claim Mr. Hannity made, which supposedly influenced Mr. Joyce, were made on March 9, 8 days after Mr. Joyce had already embarked on his cruise on March 1, according to the timeline in your report. Mr. Hannity informed you of this fact when he provided you with an exhaustive timeline of his coverage of the My Sharona Cyrus in a near hour-long telephone call that he had with Mr. Smith prior to publication of the March 22nd, 2020 story. This is another highly material fact in that it demonstrates alleged actual knowledge of the allegedly false statements prior to the allegedly false statements being made in the report. But then we get into a super-duper highly material fact and something that I consider to be the definition of fake news. After you published the April 18, 2020 story, you then underhandedly edited that story to include a statement from Fox News which disproved your timeline without notifying your readers that you were correcting or retracting your original false statements. This further evidences your malicious intent to harm Mr. Hannity. Let me know if you agree with me, but I consider the stealth edit to be one of the defining characteristics of fake news. It's even more insidious than one of the other defining characteristics of fake news, that being run a story that turns out to be false, that gets tons of traction, but run a retraction that gets no visibility at all. The stealth edit that does not specifically identify that which was edited is not just fake news, it's fundamentally dishonest. I recently heard an expression that is attributed to Denzel Washington, but I'm not sure if he was the first person to say it, that those who don't read the news are ill-informed and those who do read the news are misinformed. Stealth edits that do not specifically identify that which was edited should not just be deemed to be unethical, I think they should be outlawed altogether. We have the standard allegations of malicious intent because, as we all know from the series of vlogs I have done on defamation, in order to succeed on a claim of defamation when you are a public figure, you have to prove the actual malice of the people who made the statements. Where did this legal standard come from, you might ask, if you haven't already seen a number of those previous vlogs? Well, it came from a lawsuit called Sullivan versus New York Times in 1964. And lo and behold, in that lawsuit, the New York Times was again being sued for defamation for running, yet again, false and inaccurate information in the way of an ad in their newspaper as relates to the police force of Montgomery, Alabama. Now, we've already talked about that lawsuit at length in previous vlogs and live streams, so if you don't know what it is, go Google it just to get an idea. But that is the legal reason for why we always see accusations of malicious intent in these types of letters of demand and lawsuits, because that is the legal requirement in order to succeed on a claim for defamation when you are a public figure. But let's continue reading to find out why exactly this letter of demand is 12 pages long, and spoiler alert, a part of this letter of demand is intended for the courts, and the other part of this letter of demand is intended for the public. Mr. Hannity has never disseminated misinformation about the Sharona Cyrus. On the contrary, Mr. Hannity has extensively and truthfully covered the virus and the seriousness of the Schmashmendrick during the same time that the New York Times was minimizing the seriousness of the Schmashmendrick, including during the purported crucial and critical time period of late February and early March that you describe in your March 22nd and March 31 stories, and Mr. Hannity continues to extensively and truthfully cover the Sharona Cyrus. By way of example, 1.5 pages of shameless self-advertising by way of links and excerpts to Fox News coverage to show how much better Fox News coverage has been than the New York Times. I say that tongue-in-cheek, but what is patently obvious is that these 2 pages are not intended for the court of law. These are intended for the court of public opinion once this letter of demand is made public by Sean Hannity himself. And I'm not faulting Fox News for doing it. This is the nature of the game that the New York Times is playing. When the New York Times is running as news hit pieces on Fox News, they should expect a response. And then we get back into the legal side of the letter of demand. Your publication of the above false and defamatory statements constitutes libel. A statement that carries a false implication is defamatory where, quote, the language of the communication as a whole can be reasonably read both to impart a defamatory inference and to affirmatively suggest that the author intended or endorsed that inference. As detailed herein, the stories at the very least impart the false and defamatory inference that 1. Mr. Hannity's on-air statements on March 9, 2020 caused Mr. Joyce to believe that it was a safe to take a cruise on March 1, 2020 that apparently led to his death. Just to open a parenthesis, I am faithfully reading the typo in that sentence, but not to mock the typo at all. The only people who mock typos in letters of demand or lawsuits are bad lawyers. And 2, Mr. Hannity allegedly disseminated, quote, misinformation about the Schmashmendrick. Both of these implied statements are completely false. Moreover, the language in the April 18, 2020 story reflects that you intended these false inferences by how you deliberately manipulated the wording to create this false narrative. The stories also encourage readers to draw the false conclusion that Mr. Hannity has no concern for the lives of his viewers. And now we're going to get into a question of law that I actually brought up in the Donald Trump versus CNN and New York Times defamation lawsuit, that being the difference between statements of opinion and statements of fact, statements of opinion being protected speech and cannot therefore qualify as defamation. These false statements do not constitute protected opinion. A statement is not an opinion if, quote, a reasonable listener could have concluded that the defendant was conveying facts about the plaintiff. You have acted with actual malice in publishing the foregoing statements. As detailed herein, it was readily apparent at the time of publication that Mr. Hannity had devoted substantial, truthful coverage to the My Sharona Cyrus, and his remarks attributed by you were made 8 days after Mr. Joyce had already embarked on his cruise. Thus, you consciously disregarded the falsity of your statements in publishing them. See New York Times versus Sullivan. Now, this is an interesting strategic decision in law to make, to cite a precedent that does not support your position. It's nice to cite New York Times versus Sullivan in your letter of demand, but that lawsuit did not end in favor of the person who claimed to have been defamed. The Supreme Court, in fact, unanimously rendered a judgment against the very position you're arguing for in this letter, in that they found in favor of the New York Times that they couldn't be held liable for defamation. Yes?
We're hula hooping. We're going to the,
Hello!
turn the car on?
I have to roll the window down. I don't know how to roll the window down without turning the car on yet.
Okay, we're going for a picnic.
Okay, I'll be there in a few minutes. I know that Hannity's lawyers are citing that decision to evidence the fact that they are meeting the actual malice criteria. But the problem remains that that lawsuit was rendered unanimously against the very position that Sean Hannity is arguing for in this letter of demand. If you've been watching my channel long enough, you know that I personally believe that it is time to, if not revisit, overturn New York Times versus Sullivan, because there's just too much rampant abuse going on in the media today. But all that to say, when citing jurisprudence in letters of demand or court proceedings, make sure you pick cases that support your decisions, and if you're picking cases that don't, make sure you distinguish them from your case. And now moving on to a couple more pages, which is clearly not intended for the court of law, but clearly intended for the court of public opinion. Your malice is further evidenced by the clear bias you have exhibited by your repeated attacks against Mr. Hannity and mischaracterization of his coverage of the Sharona Cyrus, all while disregarding numerous statements minimizing the schmashmandrick by the Democratic Party politicians and Democratic Party friendly media outlets, including during late February and early March, which you proclaim to have been a critical and crucial time period. By way of example, New York Mayor Bill de Blasio minimized the seriousness of the Sharona Cyrus on numerous occasions, including, and you can read them yourself. New York Governor Andrew Cuomo minimized the seriousness of the Sharona Cyrus on numerous occasions, including, and you can freeze and read them. Dr. Fauci, one of the nation's foremost infectious disease experts, minimized the seriousness of the Sharona Cyrus on numerous occasions, including, and you can read them. Speaker of the House Nancy Pelosi minimized the seriousness of the Sharona Cyrus on numerous occasions, including, and you can read them. The Washington Post minimized the seriousness of the Sharona Cyrus on numerous occasions, including, and you can read them. CNN minimized the seriousness of the Sharona Cyrus on numerous occasions, including, and you can read them. As far as I am concerned, all of what we just went through is absolutely irrelevant in a court of law. It's not because other people did things that you are not guilty of having done the same thing yourself. I am also firmly of the opinion that none of this was intended for the court of law. All of this was intended for the court of public opinion. Your attempt to single out and attack Mr. Hannity for his Sharona Cyrus coverage, when he was more responsible in his coverage than all of the foregoing individuals and media outlets, and your intentional disregard for the foregoing irresponsible Democratic Party politicians and Democratic Party friendly media outlets, including ABC, NBC, CBS, and MSNBC, establishes clear bias on your part in connection with Mr. Hannity and the stories. Please confirm in writing within 24 hours of transmission of this letter that you will retract, correct, and apologize for each of the foregoing statements. Standard and predictable legalese, it is literally a cut and paste from every letter of demand, and they end the letter of demand as follows. We look forward to your prompt response to this letter. Very truly yours, Charles Harder. And how did the New York Times respond? Well, according to a tweet by one Eric Wemple, the New York Times attorneys responded as follows. Dear Charles, I write in response to your 12-page letter alleging that your client Sean Hannity was defamed by 3 columns in the New York Times. The columns are accurate, do not reasonably imply what you and Mr. Hannity allege they do, and constitute protected opinion. And if the response letter had just ended there, I dare say it would have constituted a perfect response letter. But it goes one sentence further. In response to your request for an apology and retraction, our answer is, quote, no. Sincerely. This is something I've said in previous vlogs, and it's actually a principle by which I live my life. Draft, act, and speak in such a way that one day a judge will read, hear, or see what you've done. And when I say it's a principle by which I live, the judge I'm thinking of is not necessarily a judge in a court of law, but, any cosmic judge that may exist. So just assuming that the document that appears in that tweet is in fact the New York Times response to Sean Hannity's letter of demand, everything about that response was perfect except the last sassy sentence. If this goes to court and Sean Hannity ends up in front of a judge that happens to side with Hannity heavy on the substance, what is that judge going to think of the New York Times response? That last sentence embodies arrogance, pomposity, and intransigence, and while it might be wildly popular on Twitter, it might not be as popular in a court of law. But even if my client wants me to respond with sass in such a way to make them feel better, my job as a responsible attorney is to say, no, slow down a little bit. A judge might read this at the end of the day. What are they going to think about it? In response to your request for an apology and retraction, our answer is, quote, no.
Oh, snap! Burn!
The proper and judicious response, the one that has no chance of coming back to bite you in the butt, would have been, sorry, we disagree with you. We are not going to issue any retraction. Do govern yourselves accordingly. But no, in as much as we have a letter of demand that is partly drafted for public consumption, we have a response letter of demand that is equally partly drafted for public consumption. And with that said, the sun is virtually at high noon. I had better go join my wife and kids for the picnic in the park. If you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. It feeds the algorithm. If you want to support the channel, all of these support links are in the pinned comment. But above all else, take care of yourself, stay safe, stay healthy, and now you know your vlog. Peace out. Booyah!